Welcome to Bloomberg Law. I'm Lee Pacchia. Joining me now is Stephen Lofchie. He's the co-chairman of the Financial Services Department at the law firm Cadwalader, Wickersham Taft. Welcome.
Thanks for having me back.
Thanks so much for coming back on. So we were talking about the markets the other day, and you said that broker-dealers are having a difficult time in the marketplace because they face a moving regulatory and legal target. What exactly did you mean by that?
Well, in a good financial system, a good legal system, you have a relative stability of law. You know what the rules are, and that's one of the things that enables you to plan. Mm-hmm. And it's really one of the advantages, I think, that the United States has had over other parts of the world in economic competition, is that you come to the United States, you feel confident about the body of law that you're dealing with and the regulators that you're dealing with, and that lets you think many years into the future in terms of building infrastructure and hiring people and starting new businesses. And right now we're in a phase where law is extremely uncertain. We've got Dodd-Frank, which rolled back, the implementation has been rolled back once. I would expect it's going to be rolled back several more times.
Why do you expect that? Is that just because of the way Congress has been operating as of late, or is there something particular about the regulations in Dodd-Frank that just aren't going to be able to come online in time?
I think there are significant parts of it that aren't really workable as a practical matter, and I think the scale of it is just so big that the ability to implement both by the regulators and by the industry, the amount of time was severely underestimated. I've seen, for example, estimates that the CFTC, kind of in the pre-Dodd-Frank era, would adopt perhaps 10 new rules a year, and now we're talking about adopting a couple of hundred rules.
Right.
Well, that's just on a different scale.
Right. We were talking before about the cost-benefit analysis that regulators are normally supposed to go through before bringing rules to bear, so to speak. Can you take us through that process? How is that normally supposed to work, and what happened in the instance with Dodd-Frank and everything after the credit crisis of 2008?
Well, in some ways, let's talk about the way that it generally works, or historically has worked. I would say historically it has been a formality honored in presentation, but not really taken very seriously by the regulators. So there is a requirement that the regulators perform a cost-benefit analysis. There are always numbers in an SEC rule which indicates that the benefits outweigh the costs, and therefore we should just go ahead with the rule. And historically, in industry, no one in industry really wants to step up and challenge that. And so we've all, looked at the numbers and said, hey, these don't really add up, but who is going to step forward and challenge it? So recently, though, the Chamber of Commerce and others did challenge the SEC on a major rule, and it went to the D.C. Circuit, and the D.C. Circuit said to the SEC in extremely, extremely harsh terms, you did not perform a proper cost-benefit analysis. So what that says to the market is the courts are going to take this seriously. At the same time, the Inspector General of the CFTC has said, just looking at the CFTC itself, as an agency, we don't perform cost-benefit analysis properly. And the Inspector General said, look, you don't even have economists looking at your cost-benefit analysis. You have lawyers, and they're not qualified to do so. And you have internal people at the CFTC saying that the CFTC isn't performing cost-benefit analysis properly. So you have industry knowing that the regulators are, I'll say, vulnerable on this. You have the regulators historically not really having taken the requirements that apply to them seriously. And you have some laws where I would say the rules that they might require, the cost will outweigh the benefits.
Right. This sounds like a recipe for litigation. Tell me about the litigatory landscape. Have we seen an uptick in cases yet? And if not, do you expect that to happen, and when?
I would expect it to happen as final rules are adopted. So now is not the time for a litigant to challenge rules, because for the most part the Dodd-Frank rules are in the proposal stage. But as rules move into final stage and are actually adopted, I think you will see litigants come forward and say, look, regulator, this analysis of costs doesn't hold up. Where's your analysis of the benefits? Did you consider everything that was in the comment letters? So that will entail, I think, another pushback on Dodd-Frank implementation. Based on litigation history and what we know about the existing process, I would not expect the regulators to win all the cases. You would have to think that the litigants would go in knowing that the regulators have been historically weak in this area.
When you speak to people, perhaps many of them are your clients in the broker-dealer community, is there a specific rule or a set of rules that particularly gives them a hard time? And we talk about uncertainty or absence of clarity to a great extent, but when you get down to it, the nitty-gritty, is there a specific rule or set of rules that is giving them a particularly hard time?
Well, in terms of Dodd-Frank, I would say, among the rules that are giving proposals that are giving them uncertainty is what are going to be the documentation requirements as between a firm and its customer, or another set of rules, or what are the obligations that a firm owes to its customer. So if you're my customer, at what point do I have to say, oh, I don't know if you should be doing this trade, Lee? Now, in order for me to say that, I have to know a great deal about your financial situation away from the trade that you're doing with me. So I have to know what other assets you have, what other liabilities you have, how risk averse you are. And so it's not enough for me to just say, oh, this trade is okay or not okay. I have to really know the entirety of your financial situation. And so that can be quite a complicated matter if it's not just Lee trading with me, but it's a company or a pension plan that itself has a very complicated financial situation. Right. So I think firms aren't sure how they're going to be able to handle that responsibility for their customers.
Just talking about these issues and timelines, it's impossible to consider them without thinking about what this means to the banking industry on the whole. Last week we were talking about the unauthorized trading loss at UBS, something to the tune of $2.3 billion, an enormous amount of money. Do you see the discussion on regulating the banks as it evolves? How do you see the issues with broker-dealer regulation fitting into the conversation? Is this something that's all going to end up in the same form at a certain point, or is this a totally separate issue?
Well, I think it's an important issue, and I think it is, in a lot of ways, I think Dodd-Frank is a distraction from the real regulatory problems that exist. In other words, Dodd-Frank is about things like clearing soybean swaps, right, which I don't think is
very granular.
And I don't think is central to our issues.
Right.
If you look at what's going on, for example, with a Lehman estate, which is still in the process of being unwound years later and is not close to being finished, what are the problems that are causing delay? It's actually very mundane things like terrible record keeping. And there's lots of places where we could be really improving our financial regulatory system by, focusing on nuts and bolts of what are the records, how is custody kept. And instead of doing that, instead of focusing on those nuts and bolts, we're worried about soybean swaps. Our attention's in the wrong place.
And finally, you just wrote a book on this subject. It's called The Lofchie's Guide to Broker-Dealer Regulation.
I really like the sound of that,
It just rolls off the tongue. How does one write a book on this subject amid so much uncertainty? This must have been a maddening process.
You do. It is true that you write one chapter and it immediately
and you
needs
throw it
to
out
be
the next day and
updated.
rewrite
Right.
it. Yeah.
But the secret is the book is online, and that's really the only way you can produce
so that's the
something
secret.
meaningful.
All right, well, I recommend everyone go check it out.
Thanks
Steve,
very much.
Thanks so much for coming by today. That's Stephen Lofchie. He's the co-chair of the Financial Services Group at law firm Cadwalader, Wickersham Taft. If you'd like to learn more about the issues we just discussed, go check out our offerings on BloombergLaw.com. I'm Pacchia. Thanks for watching.